So this time we'll call the meeting to order. Call the meeting to order. I need an approval of the August 25th, 2025 minutes. Is that a motion?
I'll make the motion to approve.
Do I have a second?
Second.
All in favor? Motion passes. This time we'll close the meeting for a public hearing to consider the following requests. An administrative review request to establish a digital sign, 1125 West Main Street, bucket request. Tommy?
Mr. Chairman, just so to establish a little bit of procedure here, what we'll do is we will have the applicant come forward to the podium, state your name, and then talk about what kind of request that you're making here in front of us tonight. After the applicant, at that time, the board members can ask any questions that they have to the applicant. Once they're finished, the applicant can turn to the seat. Then we'll get our city attorney, Mr. Greckman, to step up and tell the city's side of the story. And then once that's finished, you can ask him any questions that you like. After that, then we will open a public hearing. If you wish to be recognized, make sure you are recognized by the chair. When you are, come up to the podium, state your name. You will then have 3 minutes. And when you have 1 minute remaining, I will hold up a 1. So when you see that, begin to please wrap up. Any questions from anyone in Gower? All right, Mr. Chairman, would the applicant please come forward?
My name is Wesley Luckett, and I first want to address you guys apologizing that I was not here at the last meeting. I knew nothing about that. So thank you very much for putting me on the ballot and having me today. First thing I want to do is hand you guys out some papers. Is that okay? Everybody can look at them. What you guys are looking at is I want to bring up what I'm working to do today is to finish a sign that I started back in 2019. I've got most of it finished. 2019 is when this digital sign was approved for me to go up. Right after it was approved, COVID happened. Right after COVID, I had some other expenses such as a roof, AC and heating units that need to be replaced. I'm now at a position where I can financially afford the digital sign to complete the original drawings, and that's what I'm doing here today. The first page is where it was approved, originally approved by the city in 2019. The picture on the back of that is the final drawings. The other one was the original sketch, and then the very back photo is where we are at today with substantial progress being made. There's just a couple additional steps that need to be done. Those being getting the sign in and welding it to the poles that you see above the wood beams. That's all I have.
Any questions from the members to Mr. Puckett? Thank you, Mr. Puckett.
Well, I got a question. So the sign that you're wanting to put up is the sign that you had initially planned to put up in 2019?
Absolutely.
Okay,
Any other questions?
I would also like to point out that I am third generation of a business that's been paying taxes in the city for 70 years. And we've been on the West Main location since 1979. I really appreciate your support. Thank you.
Thank you, Mr. Park. Andre?
Good evening. This sign application was denied because the electronic sign in the application, the building official determined was a flashing sign. Flashing sign is defined under our zoning code as a directly or indirectly illuminated sign on which artificial light is not maintained stationary and constant in intensity and color at all times in use. This clearly falls within the definition of flashing sign. Flashing signs are prohibited in all zoning districts in the town of Livingston. That's why this permit was denied. There was mention of an original request and approval in 2019. I have not seen a permit that was issued in 2019, but irrespective of that, our zoning code does provide that a building permit, which is required for constructing a new sign, shall become void 12 months from the date of issuance unless substantial progress has been made by that date on the project described therein. Well, here we are 6 years later, the sign is still not constructed, so that's not substantial progress. The sign that was requested is illegal under the zoning code. The city council has considered this matter with respect to the sign ordinance on multiple occasions, and they've elected not to change the ordinance. I'll take any questions.
Who are you? I'd like this.
This is out of order. I'll take any questions from the board.
No questions? Thank you, Rick.
Thank you.
At this time, we'll open this up for public comment. If you come forward, state your name, then you
I'm going to, I know who you are, I don't even have any idea.
that is the city attorney.
Oh, he's just, that's an opinion. He's not a judge.
That's correct.
Okay. That's all I want to know.
So,
Hi, my name is Tim Richardson. Thank you, sir. My name is Tim Richardson. Good evening. I want to thank you guys for your service to the community. I understand your role today is just to determine if the city's building inspector was correct in denying the permits for these proposed digital signs on the agenda. Based on my reading of the ordinance and based on what the city attorney says, it's clear that the city inspector was correct to deny these proposed digital signs. I don't see how a digital sign could be characterized as not flashing. When the message on the sign changes, which will happen frequently, how could it not be a flashing sign? And it's clear in the ordinance you can't have flashing signs. I will also point out that any digital sign is constantly flashing, even when the content on the sign appears to be static. To understand that, all you have to do is take a picture of any digital sign as it is displaying a seemingly static message. And when you take that picture and then you look at the picture, you'll see that it's very hard, if not impossible, to get a good view of the supposedly static image. That's because the static image is constantly pulsing or flashing at a very high rate of speed. To the naked eye, it often appears to be static, but in fact it's not. It's flashing. I encourage everyone here tonight to take pictures of these seemingly static digital signs, and you'll see what I'm saying is true. As you and your fellow BZA members deliberate on this issue, I hope you will consider not only the clear language of the ordinance that prohibits digital signs, but also the intent behind the ordinance. Clearly, in the recent past, just in 2024, our city leaders made the decision that it was not in our best interest to have more flashing or digital signs. Why did they make this decision? I suspect that they articulated their rationale at the time, but from my perspective, it's not a good idea to allow for flashing digital signs all over town. These signs detract from our overall town aesthetic and create too much digital clutter, much like you would find in a much bigger city. I think it takes away from the natural beauty of our area. I would also like to point out that many, if not most, of the areas around our country that are thriving economically and that are known for high quality of life and for being highly desirable places to live and work are moving away from a free-for-all approach to signage where anything goes. Instead, they are enforcing ordinances that call for lower signs, more discreet signs, and more traditional signs. These thriving towns typically don't have a lot of flashing digital signs. I hope that you will uphold the city's reasonable and well-intentioned sign ordinance. Thank you for this opportunity to express my opinion on this matter.
Thank you. Anybody else? Okay, at this time, we'll reopen the community meeting for the consideration of the administrative review request to establish a digital sign at 1125 West Main Street.
And, Mr. Grappin, if you could just reiterate to the board members what the purpose of the administrative review is, please.
Again, the administrative review is just to interpret the zoning code and decide if the building official was correct in his application of the zoning code. So in this instance, the building official just decided to reject a sign permit application based on the fact that it was a flashing sign. So the question before the board tonight is, was that a correct application of the zoning code?
Thank you.
Am I allowed more time?
You go to 3 minutes.
Please, yeah.
I would like to say that Mr. Walter, I do believe, who is no longer here, did do a horrible job. When I first approached him, I did say, please look at the 2019 application. I shouldn't even need to fill one of these out. He refused to look at the application, said that I needed to fill out a new application, and it was then under the new 2024 flashing sign. And I will say this about a flashing sign comment. I think if you were to go over there to A.H. Roberts in the middle school, and you were to have a digital sign with an 8 to 10 second relay, and then have a caution sign that's flashing, I don't think you convince a teacher or student, principal, lunch lady, or janitor over there that the digital sign is flashing at them. So this is a very broad term, and this should allow room for you to decide what's appropriate. Being a business for 70 years, I think is a little different than an outside entity coming in. But again, I think we need to look at the bylaws from 2019, since this was first approved in 2019. When I approached the city, it was just to get reapproval. I was told then and there to fill this out digitally. And that's when I was sent the email that it was denied, and that's what got all this started. As far as progress being made to the sign, substantial progress, I believe being 85% complete with COVID and the other things that I've had looking at me is substantial progress. And I'm very confident that it is. I've got 3 steps to complete the sign. So.
Now, discussion among board members.
So, I mean, Wesley's got the 2019 permit here. I think, you know, from a perspective of flashing sign, unless you read the definition in city code what a flashing sign is, I believe that he's probably what most people would consider a flashing sign, you know. There's a little leeway there. The 2019 ordinance or the ordinance that was in place in 2019 allows for the permit to extend past 12 months if substantial progress is made. Doesn't have an end date on it, you know, so is that 6 years? I don't know. There's no end date on it, so I think that could be legally shored up in the future. I think the alderman and the board have some work to do on that to ensure that. But I'm in the belief that we honor the 2019 permit. I don't know if we're in 2025. If it was 2025 and he hadn't already made the plans to have the sign up, I think we'd be in a different situation. I always wondered why the sign looked halfway complete driving by. That's why, apparently.
I don't really have a problem with the sign either, because I'm gonna tell you the reason why. The sign's on his property, he's trying to sell his product. You've got First National Bank there to the left with a flashing sign. You have got the co-op right on the other side of the quite honest with you. I look at them when I go down through there and see what's on sale, that type of thing, and, like I said, he's been in 70 plus years or whatever. And, I mean, you know, it's his product, his sign, his property, he's trying to stay in business, I don't really blame him.
Any other discussion?
What would the motion need to be to allow the 2019 permit to continue? I mean, we're really here on a 2025 permit, not 2019.
Just need to grant the variance, don't you?
It's not a variance, it's an administrative review, so. Did Walter apply the code correctly, the way that it's written in 2025, is the question for him.
Is Walter here?
Does not person.
So I guess the question would be, like last month, we applied the ruling for the 2025 ordinance, but how does Mr. Puckett go forward with the 2019 permit? I guess is the question.
Yeah, I mean, it's just, you know, it's kind of like Andre said, do the codes enforcement, if you disagree with the ordinance, that's one thing. It's, do you agree with how the codes enforcement officer interpreted the zoning ordinance?
Would we be comparing the 25 to the 19? Based on the 25, he enforced it correctly, but there's a 19 here.
Yeah, I mean, that's, I don't know the answer to that question.
I think procedurally,
He wouldn't even take into Mr. Walker wouldn't even take into consideration to look. He told me this was the only way.
and that's correct, procedurally, you have to apply for a, new permit, but
Even if you've already been approved?
a new permit application, can take into consideration whether a previous permit was issued. Again, I've seen an application for a permit, but I have not seen an actual permit that was issued, so, I'm not aware of it having been approved, but I have seen a permit application. I think procedurally the proper thing to do is affirm the building official's application of the zoning ordinance to this application, and Mr. Bucket can file a new application based on showing evidence of substantial progress having been made over the past 6 years, and what percentage of the sign has been completed, because I don't think that was fully fleshed out in the original application. So that's my recommendation.
So we have no idea the 2019 was approved.
We don't.
We've got the application, but was it denied or approved?
100% it was approved. And the fact that the city doesn't have the signature on the approval blows my mind. What have we done with the applications? The fact is, Mr. Walters wouldn't even work with me. He said, this is the new way we're doing things. You've got to go online, fill this out digitally. You can do it by paper if you want, but I would really recommend digitally. The next thing I know, I'm working to get him to approve the 2019. Dad's saying, have you read the front page of the newspaper? They denied your sign because it was going to be flashing. And this just, and I'm here today to move forward.
Again, I have not seen evidence that the original 2019 permit application was approved. Mr. Puckett has evidence of a signature on an application approval, then I think he should reapply for a new sign permit and demonstrate that.
Any other discussion?
Does the city attorney get paid by the hour?
That is not a question for us. We're a board of zoning appeals.
mayor's behind you, Wesley, ask her.
Well, I didn't know if the board member or not. We're out of order.
We're out of order here. We're under discussion between the board members here for the motion and zoning bills. Do I have a motion before us here?
I make a motion, we, let Mr. Puttertree sign it.
So you're making a motion to grant administrative review and overturn the decision of the code enforcement
Absolutely, I'm for Mr. Puttertree to sign it.
Do I have a second?
Can we make a motion to approve the, I mean, we can't make a motion to approve the 2019 permit, can we? Like,
Our board doesn't have that scope. We're, this, as my understanding is, we're only doing the administrative review for this file permit in 25.
and I believe the penalty for building outside permits, $50 a day misdemeanor, is that correct?
Or, excuse me,
If he like went ahead and built his sign without approval.
without a permit, that would be a violation. But if the board upholds the building official's decision, he can always resubmit a new application with evidence that substantial progress was made and that this 2019 permit, if it was ever issued, is still valid, and the city would have to honor that if that's the case.
And that would be up to whoever the new codes enforcement officer is.
Correct.
Okay.
Who is that?
I don't know. Yeah, David's our board of mayor and alderman representative.
I don't think nobody's been hired yet.
That's up to you, sir.
Nobody seconds the motion? Do I have a second?
Motion fails for lack of second.
Motion fails for lack of second.
Ready? Going forward, then, so motion fails for lack of second, then application is not approved. Administrative review is not approved, is not granted.
That is correct. You need to make another motion. If you'd like.
Yes, if anybody wants to make another motion.
Any other motion required?
I don't know if this is correct, but I agree that the 25, based on the way it's written now, the codes enforcer was correct. But what we need to look for is if this was approved, to bring it back with a new application statement that this was approved and there's substantial enough construction done.
Yeah, so Mr. Puckett could come back in with a new application, show significant, significant improvement to, if there is a new, or when we get a new codes enforcement officer.
Or in the absence of a codes enforcement officer, whoever has authority over the charter to make that decision, because we want to have, speedy processing of our applications. So, if he resubmits an application showing that substantial progress was made and showing that the 2019 permit was actually issued, then I would expect the person who's reviewing that application would make a decision on that basis and apply the code. And if Mr. Puckett disagreed with it, he could come back here, or if the city disagreed with it, the city could appeal as well.
Thank you, Andre. Okay, at this time, we'll reopen the BZA. At this time, we'll reopen the BZA meeting to consider administrative review to establish, a digital sign and roll media request. Mr. Rowland?
Good evening, my name is Franklin Lemond. I am an attorney here on behalf of Mr. Rowland. We are here to appeal the denial of Mr. Rowland's initial application for a digital sign. Mr. Rutherford denied the application on the grounds that the proposed digital display would constitute a flashing sign under section 11-202.22 of the ordinance, and therefore is prohibited under section 11-203.9.2E. Now, respectfully, Mr. Rutherford's interpretation of the ordinance was incorrect because Rowland's proposed sign does not qualify as a flashing sign, because the messages that will be displayed on the proposed sign will be maintained in a stationary position and will remain constant in intensity and in color as they are being displayed. The change in the message that takes place every 8 to 10 seconds is instantaneous and does not constitute a flashing sign under the established law. Now, proposed digital signs like the one Mr. Rowland is seeking is consistent with state law and federal law on this issue. Now, of course, the Tennessee Department of Transportation has authorized digital signs like the one Mr. Rowland has requested, and they are not considered to be a flashing sign. And the Federal Highway Administration, in a memorandum from September of 2007, held that digital signs, quote, do not violate a prohibition against intermittent or flashing or moving lights. And as part of the appeal that I submitted on behalf of Mr. Rowland, there's a copy of this memorandum from 2007 where the federal government, interpreting the Federal Beautification Act, upon which outdoor advertising sign restrictions are based, held that digital signs do not constitute a flashing sign. And courts, when they have addressed this issue, have found that similar provisions regarding flashing signs do not apply to digital signs. In Visible Properties versus Village of Clemens, the North Carolina Court of Appeals held that the Village of Clemens prohibition on flashing signs did not apply to digital signs, and indeed approved the issuance of a permit for the digital sign in that particular question. Now, you can drive through and around Livingston, as I did prior to this meeting tonight, and find numerous examples of digital signs throughout the town. And Rowland just wants to be able to do business the same way that others around the town are doing business, like the churches, like the businesses, like the schools, and even the police station has a digital sign that, in fact, would be considered a flashing sign because it moves counterclockwise and moves counterclockwise as it rotates between the time and the temperature. But yet the city does not deem that to be an illegal flashing sign, one that is actually flashing. Mr. Rowland's proposed sign will be an instantaneous change from one message to the other, won't have the movement that you see on the police station sign, and won't have the movement that you see on other signs around town that aren't adhering to the prohibition on flashing signs. Now, there's another reason why, beyond the improper application of the code, why Mr. Rowland's application should be granted. The city code in section 11-203.9.1H and 11-203.9.3C establish a position that there are no limitations, restrictions, or requirements applicable to government signs. So Livingston can do whatever it wants. It can do exactly what my client requested, and nobody can stop it. But my client can't do the same thing. Now, several courts have looked at these favorable treatment of government signs and said that that's not permissible. You can't look at the content of one sign from one speaker and say that's allowed, and look at the same content from somebody else and say that's not allowed, because then you're basing your determination based on content, which of course is impermissible under established law. And in the appeal packet that I submitted for this first application, we cited four court decisions: Solantic versus Neptune Beach, Foki versus Menlo Park, Nicholas Media versus Babylon, Clear Channel versus Town of Wyndham. Each of them held that this preference for government signs, where the government can do whatever they want, but an applicant cannot, is a content-based determination and is therefore invalid. And the fact that the city is impermissibly basing its determinations based on content can also be seen by what Mr. Rutherford asked my client when he submitted the sign application. Mr. Rutherford responded in an email that specifically asks, what will be advertised on the proposed sign? Will it be used for off-premise and on-premise advertising, or just one? And if it's just one, which one will it be? So Mr. Rutherford, when he was making a determination on whether to issue a permit to my client or not, wanted to know what the content of the sign was. And of course, that's blatantly unconstitutional under the Supreme Court's decision, Reed versus Town of Gilbert. So not only is Mr. Rutherford's interpretation of the flashing sign provision inconsistent with state and federal law on this issue, but it was also based on impermissible content determinations, and therefore we would request that the board reverse the determination and approve the permit. And I'd be happy to answer any questions you might have.
I did have one, Mr. Leonard. You mentioned the 2007 memo that stated digital signs do not constitute flashing sign. Who did you say issued that memo, please?
The Federal Highway Administration.
Thank you.
Thank you, good, thank you for your time.
Thank you.
Andre?
We're here today, and this board is called upon to interpret and apply the zoning ordinance of the city of Livingston, not the Federal Highway Beautification Act, not the ordinances of the village of Clemens, the city of Livingston. We have a code, we have a definition for what a flashing sign is, and that is a directly or indirectly illuminated sign on which artificial light is not maintained stationary and constant in intensity and color at all times in use. Mr. Lemon addressed the board and stated that these digital signs will be changing every 8 to 10 seconds. That certainly is not stationary and constant in intensity and color at all times in use. We don't just reset the clock every 10 seconds and make an exception for that. The board of mayor and aldermen made a policy decision to stop the proliferation of these digital flashing signs in the city of Livingston because they are distracting the drivers. They harm the aesthetic appeal and downtown character of the city of Livingston, and that was the policy decision that they made, and they addressed this. Mr. Rowland came to the board, the most recently constituted board, just this year, and asked them to change it, and they declined. So the Board of Zoning Appeals has to apply the law as adopted by the City Council of the Town of Livingston. We have a clearly defined definition of what a flashing sign is. In the case cited by Mr. Linden, it was a North Carolina case out of the village of Clemens. Well, in that case, they didn't even have a definition for what a flashing sign was. So that case, one, doesn't apply because it's not within our jurisdiction, and two, it's factually different. It didn't have a definition, and we have one for you to apply, and that definition is clear. Again, we're not applying the rules of the Federal Highway Administration, we're applying the zoning ordinance of the town of Livingston. This has been consistently applied throughout. There are tons of flashing signs in Livingston now. The reason the law changed was to stop that. The ones that are existing prior to the change in the law, those were legal at the time and they constitute pre-existing non-conforming uses that are grandfathered in. There's nothing inconsistent or improper about that at all. The difference with government signs, there's no restriction on government signs. Well, that is proper as held by the Sixth Circuit Court of Appeals, the Federal Appeals Court with jurisdiction in Tennessee. And they held in Norton Outdoor Advertising versus the Village of St. Bernard in 2024, just last year, that government speech cannot be content-based. So, again, we're dealing with First Amendment arguments here that are forward in this court and really have nothing to do with what the board is here to decide tonight. But Mr. Lemon addressed them, and so I will too, on the record. And we have a pronouncement from the Sixth Circuit Court of Appeals that government speech cannot constitute content-based regulation of private speech. Cannot constitute content-based regulation of private speech. That's the opposite of what Mr. Lemon just told me. The same with on-premise versus off-premise. That's not content-based. We have a more recent case from the United States Supreme Court that came out in 2022, 3 years ago. And they looked at content-based regulations, and they talked about the Reed versus Town of Gilbert case from the Sixth Circuit, and they said that the Sixth Circuit went way too far in that case, and that content-based regulations are just regulations based on location. Is it on the premises or is it off the premises? That is not content-based. It does not violate the First Amendment. The Town of Livingston zoning ordinance is entirely consistent with state law, with federal law, and with the First Amendment. This board understands the clear definition, and we would ask the board to apply it and affirm the building official's correct decision.
Any questions?
Do we have any other public comment?
Public hearing.
Or at this time, we'll open the public hearing for any public comment. State your name for the record. You got three.
Marcus Roberts, excuse me, I'm a little bit hoarse. First of all, I think you did an excellent job of telling why this should not be changed. But I also want y'all to consider that you would set a precedent if you went against the codes administrator, what his decision was, and against the municipal code. And your president would allow anybody to come in here and put up a sign, because you can't just say Mr. Rowland can have a sign. What about everybody else that might want one? Or what about if Mr. Rowland wants 2 or 3 signs? You know, you're not just voting on one sign. And the other thing is you have no control over what's on that sign. I mean, it could be a business, it could be a political viewpoint. So I think you need to consider that when you think about this decision. Thank you.
Thank you, Bert. Any other public comment? With no other public comment, we'll reopen the BZA meeting for consideration of administrative review to establish a digital sign for Roland media request. Any questions or discussion? Okay, at this time, do I have a motion?
I'll make a motion to affirm the building codes director's decision to deny the permit.
Do I have a second?
I'll second it.
Okay.
Mr. Chairman, we have a motion by Nathan Dale to affirm the decision of the codes enforcement officer with regards to denying the digital sign request from Roland Media. We have does that sound correct, Nathan? Second by Tommy Rooker. Vote of yes or aye will be to uphold the decision of the codes enforcement officer. Vote of no or nay will be to overturn the decision of the codes enforcement officer. Does everybody understand the motion on the floor? Tommy Rooker.
Aye.
Nathan Dale.
Yes.
David Langford.
Aye.
Daniel Elder.
Yes.
Passes and abstain. David, or come back to you? Okay. All right, so motion for administrative review to overturn is denied. 301 Langford, abstention.
Okay. That's all business. And do I have a motion to adjourn?
Motion to adjourn.
I'll make a second. All in favor? Aye. We're adjourned.